Hi, I'm Shelley Behan, and welcome back to Fourth Amendment Fridays, where we're going to do now an application in real life of what Prouse and Cortez mean for you. So Prouse says the police can't just pull you over anytime they want. Now, there are things called checkpoints, like sobriety checkpoints or border checkpoints. That's a separate thing from what Prouse was talking about, and I'll cover checkpoints in a different video. But let's talk about Cortez, because that's a big case. And what Cortez talks about with a reasonable and articulable suspicion and a totality of the circumstances is something you need to be aware of if you're ever pulled over and then subsequently arrested for a crime. Because reasonable suspicion to stop you has to be evaluated from all of the facts surrounding the stop. So this doesn't mean that you have to go into court and say, the officer didn't have reasonable grounds to stop me. What it means is the state, the prosecutor, and the police have to demonstrate that they had reasonable grounds to stop you. You, as the accused, as the driver, you don't have the burden of proof. The state does. And the court has to review it from an objective standpoint, a review of everything that the officer knew at the time of the stop. Often, prosecutors will cherry pick their evidence and only present to the judge the bad driving behavior or the things that the officer saw which led them to believe, for example, that the driver might have been DUI. Person was maybe weaving in their lane or across the lane divider. But what they'll fail to present is something like the driver had a safe lane change, not once, not twice, but 3 times, or that the driver pulled over in a proper manner to the proper side of the road within a timely fashion. All of those last driving behaviors that I described would be the opposite of what the police are looking for in a DUI investigation. So a judge who would be evaluating whether there's reasonable suspicion for a traffic stop related to DUI should consider both the driving behaviors the officer saw that led them to believe a potential DUI, as well as the driving behaviors the officer could have seen but did not see related to potential impairment. Keep watching Fourth Amendment Friday Fundamentals to learn more about how to keep yourself safe and protect your rights in the courtroom.